Hello, everybody. This is Robert Barton here at North Carolina State University, and I will be hosting today's webinar. Today's topic for our Woodland Owner Lunch and Learn series is forest management plans, present use valuation, and voluntary agricultural districts, what a landowner needs to know. Just a couple housekeeping things before we get started. If you have questions for our presenters today, we'll be taking those at the end of the presentation. But during the presentation, when you get that question, feel free to just hit the Q&A feature and enter that question in. We'll be moderating them at the end of today's session. And with that, I'm going to turn it over to the first presenter, Dr. Mark Megalos. He is an extension professor here at North Carolina State University and works in the area of present use value taxation, voluntary ag districts, forest economics in those areas. The other presenter today is Colby Lambert. He's a certified forester. He's our area specialized agent in extension, covering forestry, pretty much just a general forestry practitioner across the board. And with that, I'm going to turn it over to Mark to begin the presentation.
Thank you, Robert, and welcome everybody. Glad to be in front of you today. I'm broadcasting today from NC State University, and with best regards from our provost and chancellor. Today I want to talk just about two different programs. They're responses to keeping the land producing either food or fiber, but they're longevity or sustainability programs. The first one is a voluntary tax program, so it's using the incentive of a tax reduction to keep land in production, in this case agriculture and forestry. The second program is more about, it's a policy directive, and for those of you not from North Carolina, it's a solution to not having statewide zoning. So we have county by county opportunity to protect farmland, and we'll get into both of these programs. They're major details and finish up with how to enroll on them. So for the next 20 minutes or so, let's talk about present use value. And as I mentioned earlier, rather than taxing land at its highest and best value, in this program we tax it for its agricultural, horticultural, or forest productive capacity. So that means it's soil-based. Your best lands will have the highest tax value, and likewise some of the least productive lands the lowest. It's a voluntary program, and so in order to get the benefits of the program, you must apply. So how the program works, we're talking about not, well, it's a reduction in the taxes people actually pay, but the fair market value is known and it's recorded, but also the farmland value is known, or that known as the present use value, is the one that you're taxed on. Those market value taxes are deferred, but they can be reinstated, and that occurs when the land use changes. And that's the one thing that the program tries to thwart, because once that land changes use, the full tax is reimposed. And it's not just for a single year, it's the 3 previous years, and then the current year is due in the full amount. So that deferred amount, or that reduction that people enjoyed for however long they were in the program, that's removed immediately, and then taxes are due as well as an interest payment on them. So that's the stick part of the program, but the carrot part is very, very useful and very popular in North Carolina, and it's been a model that's been reused in many other states. So yours may, if you're in another state, your program may be known by another name, sometimes the title of the legislation, but it's basically a reduction for productive land. So there are some qualification requirements. The biggest one is the ownership for 4 years. With the ability in this program to reach back 3 succeeding years, you can see why the 4-year ownership provision came about. But that's waived if you happen to live on the property. So if the property that you're enrolling in the program has a house on it, or you live there, and it could be any kind of house, you can apply immediately. So the acres that will be reduced in the program have to be in actual production. And there are ownership requirements and acreage minimums. For instance, in the horticultural arena, you'll need at least 5 acres. In agriculture, 10 acres. And then forestry is 20 acres in actual production. And while agriculture and horticulture have an income requirement, the qualification for the forestry lands is a management plan, and that's how you qualify and also maintain your eligibility, by following that forest management plan. So why the program matters? Right off the bat, you start saving annual taxes. So instead of being paid or being charged the fair market value, you're going to pay just on the land's ability to produce. As a result of that, it keeps agriculture, horticulture, and forestry production in the state economical, because even in the urban areas or the surrounding suburban areas, these operations remain profitable. The program's requirements ensure that the land is soundly managed, and there's a reward essentially for active production. So the idea is to keep the land producing, and to incentivize that, you are only taxed on the land's ability to produce. So there's been some confusion on the program. It's not a tax giveaway, but it's actually an earned deferment of those taxes by keeping the land green and in active production. So a few details on how to enroll. You start at the county tax office. There's a 3 or 4 page application. They want to know the history, the productive capacity of the land. If it's a forestry type plan, a plan is needed at the time of application. And typically in a standard year, you apply in the January listing period. So because of the beneficial aspects of the program, especially towards profitability and reduced cost on an annual basis, this should be your first step if you have land that qualifies in any of those 3 productive capacities. So enroll in the program, and then the rewards will keep coming. Okay, that was pretty much our first program area. And again, it was an incentive program based on reduced taxes. The next one is more of a policy approach to establish in each county, and those counties voluntarily agree to create an ordinance that allows for these voluntary ag districts. And the purpose initially was to increase identity and pride in the agricultural community and its way of life. But with the ordinance comes increased protections from nuisance lawsuits. Those are maybe neighbors moving in nearby and claiming that they didn't know a farm was noisy or dusty or may have odors at different times of the year. So that's the nuts and bolts of the program. Let's talk about some of the details. So how it works, we said it's voluntary, just like present use valuation is, but the counties voluntarily establish an ordinance. Through that ordinance, we create an advisory board that essentially runs the program, accepts and reviews those applications from farms, and then in a grander sense, it promotes or provides a voice for farm, forestry, horticultural interest in local government. So it's established by the local government, but it's an advisory board. Beyond that, the board can and will advise the Board of Commissioners on current agricultural issues. They'll do the day-to-day work of running that program. And in the case of a potential condemnation of an acreage that's in the Voluntary Ag District, they would conduct and hold the public hearings on public projects that could lead to the condemnation of farmland. So the ordinance itself establishes this procedure, and the board is there to protect those folks in the program. So the benefits that come from an agricultural district or voluntary ag district is pretty much the halting of the condemnation of farmland until such time as a public hearing can be held on that condemnation. So it's one more step in the process of eminent domain or the condemnation of properties for public uses. And in many cases, these are transportation-like projects, or at least those are the ones that have prompted a public hearing to date. So it's one more level of protection of farmland at the county level. The most important one for most of our farm producers is if they're in between the town and future development, oftentimes a sewer or water lines have been placed up to and beyond their farm. And if one is in the voluntary ag district, those assessments to connect to water and sewer, or even the placement of those assessments on their farmland is waived until such time as they want to make that hookup themselves. So it's an avoidance of quite a bit of cost on their end, but it's a big deal for rapidly growing areas. The other thing that's been added to the legislation is a record of notice. And how this essentially works is that for properties that are sold in the vicinity of a voluntary ag district, you see that 1/2 mile area, that as people close on those properties, they're going to get a notification with their deed or be alerted by mapping and signage that they're in fact in a voluntary ag district. And those signs change, but the recording of that notice along with the deeds allows future owners to know that they're in a voluntary ag district. And so that tractors on the road or plowing or late night machinery use, especially during harvest time, may be part of what they're signing on to. So a small but an important part of protecting that rural way of life, or at least the farming life in developing areas. So there are pros and cons to this approach. It's voluntary and it's very flexible. The counties run their boards essentially as they see fit. There's a lot of assistance from the state level, but it is a local program. But there are limits to the program too. There's no absolute protection against nuisance suits. There are still lawsuits that can be entered in against farming operations. And because it's voluntary and not a statewide level program, it's going to be ununiform or ununiformly applied across the state. But for those 90 of the 100 counties in the state, it's a good start. So one thing about the program we haven't discussed in full or detail is that as a part of the voluntary aspect of the program, the landowners agree not to develop or change their land use for the next 10 years. But with that agreement, they're not precluded from developing residential lots, let's say for their family. So up to 3 of those are allowed. Because it's a voluntary program, the VAD allows landowners to withdraw upon written notice. And these agreements may or may not be recorded under the typical program. There is in the last few years, been an enhancement to the voluntary ag districts where, as counties upgraded their ordinance, if you will, those conservation agreements become irrevocable for that 10-year period. So they're essentially a term easement, a decadal, and they automatically renew on a 3-year basis unless the landowner chooses to withdraw. So there's a little bit more teeth in the enhanced protection, and as a result of that, there are a little bit greater benefits from those. The one in detail at the bottom of this list is a 90% cost share eligibility for landowners in an enhanced district. So less cash outlay if they're working with like-minded conservation programs. EVAD, or Enhanced Voluntary Ag Districts, may receive priority too in the receipt of grants and things from the state. In addition, the enhancement allows for the sale of non-farm products without losing the zoning exemptions that go with typical ag. So farm level businesses or farmers type markets sold on the property will allow for, in addition to the products produced there on the farm, they may have other agritourism items or things not related to the farm per se. So for enrollment in this program, typically in the state, your first contact would be the county soil and water district office. Again, 9 out of 10 counties in the state, or 90 of our 100, are either in the voluntary ag district ordinance or have enhanced theirs. There's an application that you can receive from that advisory group, and then you can apply at will. So I'd just like to wrap up a little bit, and it's going to be a summary of both of those programs. So just as a reminder, present use valuation, or PUV as the agency folks refer to it, defers the taxes, reduces them in high real estate areas to a level that is comparable for any farmer producing on similar productive lands. PUV and voluntary ag districts protect that working green space with various levels of protection. Both of them, in a sense, have a production or a sound management requirement, and at least for PUV, an income requirement exists. They're both voluntary programs, so the onus is on the landowner to go ahead and enroll. And if either of these is of interest to you, we encourage you to follow up with those people. So I will stop there and turn over the reins to my colleague, Colby, and we'll come back for questions in a few minutes. But thank you for your time.
All right, thank you, Mark. Again, my name is Colby Lambert, and today I'm going to talk to you a little bit about management plans and why you need one. And Mark talked about the present use tax program, and you have to have a management plan in order to enroll in those. So we're going to talk a little bit about the definition of a management plan, why you need one, the types of plans that you can get, and then we're going to talk about those plan components. Programs like the present use tax program, they require certain components to those plans. And if you get into a program like the tree farm program here in North Carolina, the plan has to have a certain set of criteria in order for you to qualify for that. So let's talk a little bit about the definition of a management plan. So a management plan describes the current state of your property and also the steps that you're going to take to achieve your ideal forest. So here in this picture, we have a young longleaf pine stand. You see a lot of loblolly pine that is encroaching in that stand. And the management plan will help you get to your ideal forest, which for most owners with longleaf pine, that's this picture here you see is kind of the ideal longleaf pine savanna forest. So the plan helps you establish a logical sequence and timeline for those activities that will help you to achieve your desired objectives, whether it's for timber, wildlife, water, aesthetics, or beauty, and leaving a family legacy. It also helps you with required documentation for financial assistance, for the preferential tax treatment or PUV, compliance with certification programs, and in some cases, state and environmental laws, depending on where you're at. So if you want to get cost share assistance through your state forestry agency or through NRCS, you will need to have a management plan and have those documented. So there are a couple of types of management plans that we're going to be talking about. One of those types are plans that qualify the property for programs such as tax reduction and also forest certification. And then we'll talk about plans that accomplish specific goals of the landowner or may carry out a specific management task. Both of these types of plans outline the landowner's goals. And that's the most important thing, is making sure that your goals are outlined in the plan and the steps that you're going to take to achieve those goals. So a qualifying management plan is a tax plan, is one of the terms that we use here in North Carolina. And those plans are used to get the landowner's property into the present use tax program. There's also a stewardship plan through the North Carolina Forest Service here in North Carolina, and that can be used mainly as a recognition program, but it's a more detailed management plan than our tax or present use value program plans. And then there's also the tree farm program. Here in North Carolina, we do have the forest certification program through our tree farm program. So those plans are a lot more detailed and require a lot more elements than the normal tax plan. And we'll talk about those a little bit later. We also have what we call action management plans. And these can be for a single practice plan or prescription, whether it's for wildlife management, conservation plans. As you see here in this picture, we have a pre-commercial thinning operation that was done. In a lot of cases there, North Carolina Forest Service will write these single practice or prescription plans for landowners in order to help them achieve a specific management goal that they're trying to achieve on their property. But also with wildlife management plans or conservation plans, it could be looking at a certain conservation practice or wildlife management habitat practice that can help the landowner achieve a specific goal. So when we look at why we need a plan, so the first requirement for here in North Carolina, the biggest thing that Mark was talking about was the present use tax value. And in order for a forest landowner to participate in that program, is they have to have a management plan that shows sound management when it's implemented. It also has to show timber production. And so in the case of the plan for the present use management program, it's required for that program, but also a plan could be required for certain other programs, whether it's a cost share program or certification program. And in some cases, it could be used for the IRS or other legal statutes. Of course, for the VAD program, that is also part of that as well. But it gives you a pathway to achieve your goals, and also helps you to manage your land for what you're wanting to do with it. So let's take a look at some plan components. And these components here reference primarily to our present use tax program. So for that program, the management plan has to have 5 elements in the plan in order for it to qualify. So first, you need your landowner objectives. You need to have maps, aerial photographs, location maps. You also need the forest inventory or description. You need your forest management prescriptions, and then you need harvest dates, methods, and regeneration strategies. So those are the 5 requirements for the present use tax program here in North Carolina. And the first one of those, again, is your management and landowner objectives. And for the present use tax program here in North Carolina, the biggest objective, or the #1 objective, has to be commercial timber production. In order to qualify for the PUV program, commercial timber production has to be part of that plan. If they come back and audit and they don't see that you are following the plan or doing any type of harvest or thinning or other thing that's going to produce a commercial product, timber product from that land, then you may be expelled from the program. So that's an important part of that PUV program. So you also need to have a location map or aerial photograph showing where the property is located, showing the boundaries of the property, and also showing the types of timber that's on the property. The next thing you need to have would be your inventory or description of the stands that's on the property. And whether it's for the PUV program or just a general forest management plan, you need to have a starting point for the management. You may need an inventory to establish your timber basis, but it's crucial in order to formulate the management prescriptions. In order to figure out what you want from your property and where you want to go with it, you need to know what you have to begin with. And that's where this inventory and description comes in. So you need to have a good starting point in order to carry out the management plan. And then you need to have specific forest management practices. So this is another part of the PUV plan. So if you're starting a new forest and you're planting or doing a seedling herbicide release, a site preparation, whether it's mechanical or chemical, you need to have that in there. Whether or not it needs pre-commercial thinning. So this is the start of the new forest. If you've got young forest on your property, you need to think about thinning, prescribed burning, those practices that you're going to do for those young forests. And then when we get to our middle-aged forest, you need to look at whether you're going to prune, maybe do a mid-rotation herbicide application after a thinning, or a fertilization application after thinning, or whether you're going to do more prescribed burning. So those are those practices or prescriptions that you need to have in that plan. And for our older forest, we want to look at whether we're going to do a clear-cut harvest, a selective harvest, a shelter wood harvest, and how we're going to do those. You may need to have a plan about stream crossings, those sort of things in there as well. So those are some of the specific practices that you'll have to have in those plans. And then the next thing is need to know about harvest methods and dates. So establish a target harvest timetable for each stand. And especially here in North Carolina for those present use tax plans, you need to have a timetable. You know, specify the type of regeneration or harvest, whether it's going to be clear cut, a seed tree, shelter wood, or selection harvest. And then you also need to talk about regeneration systems. So the types of regeneration techniques that you're going to use to establish a new forest. Because the key to the present use tax program, or any forest management program for that matter, is the renewal of the forest or the regeneration of the forest. Because if you harvest the timber and then you don't, you know, if you switch to another use type, then that's probably going to kick you out of that present use tax program. So you need to know how, you need to have a plan on how to get the next generation or the next forest going. And that could be whether it's natural regeneration or planting of trees. So next we're going to look at some additional components for management plans as it pertains to the tree farm or stewardship plans. So here in North Carolina, for stewardship plans and tree farm plans, those plans can kind of they can be intermingled for each other. So a stewardship plan, if it has all the components that would meet the criteria for a tree farm certification plan. So some of the additional components, or you need to have information in your plan about forest health. You know, and you also need to talk about soil conservation, some of the ways that you're going to manage for soil conservation, water quality, how you're going to manage for water quality. There also needs to be a statement in the plan about threatened and endangered species. You know, if you've done an assessment of those on your property, if there is T&E species on the property, how you're going to manage for those, because there are special considerations and requirements for managing for T&E species. Another thing is invasive species management. You know, seems like each year that we have more and more issues with invasive species. We have more and more species that's coming along in every state, not just here in North Carolina, but every state, that we need to address in our management plans and make sure that landowners understand that, you know, how to address those issues with invasive species. One of the special components with tree farm is a term called special sites, and that could be anything from a cemetery that's on the site to an old home place. Could be an old grist mill or any type of special thing that, or special feature on that property that the landowner deems special to themselves, or is something that's special on the property, and they need to make sure that that is addressed in the management plan. And then one of the things for tree farm certification is a term called the Forest of Recognized Importance. And that's a term that is used for a kind of a landscape-wide special forest, or some type of special, you know, a recognized, nationally recognized importance. So here in North Carolina, one of those could be our longleaf pine habitat, and that would be, you know, an area of forest of recognized importance would be our longleaf pine. It could be a forest that borders a national forest or something of that nature. So that would be the forest of recognized importance that would need to be addressed in a tree farm plan. Also, recreation and aesthetics is another one that in the stewardship and tree farm plans it needs to be addressed. And then wildlife management. What you're going to do in regards to wildlife management, if you have special interest, whether it could be quail or wild turkey or bear or any type of wildlife, and how you're going to manage for that. So when we look at this, I want to talk about where to get a plan. So this comes from the present use tax program guide here in North Carolina, and this is straight from that guideline, and this talks about who can write the plan for the present use tax program. And it reads, forest management plans can be prepared by an independent consulting forester, by a forester with the North Carolina Forest Service, and also by the property owner. However, if the owner prepares the plan, they must have appropriate management skills and analysis skills to properly prepare a plan that's comparable to what a qualified forester would do. So the owner can do it, the Forest Service can do it, or a consulting forester can write the plan. So here in North Carolina, our North Carolina Forest Service, they do write plans, forest management plan, forest stewardship plan. The fee for those is $5 per acre. But also, as we talked about with the practice plans or a specific management type plan, the Forest Service will do those at no additional cost. So this includes a site preparation plan, a tree planting plan, a prescribed burn plan, a thinning or final harvest plan. So all those can be done at no cost, but those are very specific types of practice plans. And your local county forest ranger is the first point of contact for the Forest Service. Consulting foresters here in North Carolina, our Forest Service has a contact page that you can look up consulting foresters in each of our 100 counties. That is the first website link there that you can get those to those contacts there. Also, the Association of Consulting Foresters has a directory of consulting foresters that are ACF members, and that can be found there on that link as well. Again, for consulting foresters, these fees can vary. They're based on the time, acreage, and other factors involved with producing the plan. And with that, Bob, I guess we'll take any questions.
Thank you, Colby, and thank you, Mark, both for putting today's presentation together. We have received some questions, and we will work through those. Folks, as you get questions, please type them into the question and answer feature here on today's webinar. Click on the Q&A, and it'll allow you to type in your questions. Our first question is related to the enhanced voluntary ag districts. And it's from Chris Smith, wondering what is the 90% cost share of EVAD? Cost share on what? And then any cost share for forestry activities?
That's a great question. In the interest of time, I probably went a little fast over that, but those are qualifying cost share programs typically run by our North Carolina Department of Agriculture. It can include, in fact, cost share on developing a county-wide farm plan, farm protection plan. That was one of the goals of their big grant program, but it can also be on cost share related to the sale of easements and putting protections on those properties. So it can be, in fact, ag and farmland development trust fund dollars, but it can be dollars coming from other entities like the Sentinel Lands Project and funding from military groups and the REPI fund and those kind of things. So where it can be applicable, it would be, you know, the highest amount of cost share available. And it was in a way of incentivizing the ordinance, stepping up the ordinance from the voluntary program to the new enhanced one.
All right. Next question is, by the PUV legislative law, why can't a North Carolina registered forester be qualified to prepare a forest management plan? Not all RFs are designated as consultants, but RF. Mark, I think that's another one for you.
Oh, okay. I'm not sure because Colby covered some of it. I don't think there's a preclusion from typical foresters. I think that just the consultant is a designation we use for someone preparing plans as a private individual for hire. But most of our service foresters are registered foresters, and they can prepare plans and do the bulk of the forest management plan preparation. So I don't think there's a preclusion on that per se.
Okay. So here's a question from Amanda Hatcher in reference to PUV. And she's wondering if you are converting from forest, you have an area that you have harvested and you're going to convert it to a pasture or field crop use rather than regenerate it back to a forest. Can you go right back to PUV?
Is that one listed in the, where's that one listed so I could see the title?
Oh, you have to open the question and answer feature, Mark.
Okay, I do have that one open, but I don't see that question per se.
Oh, sorry, that's in the chat window.
Okay.
My mistake.
All right, so I'm opening the chat now. I'll take a look at it.
Okay.
So the question is, if you're converting from a forest harvest to a pasture or field crop, the problem with that, the answer is probably not, because in many cases you have to establish that income history. So you need at least a 3-year period. It really depends on the county, but typically the conversion from ag land to forestry is simple and could be almost instantaneous. You put a tree in the ground, have the right amount of acres, and you qualify. But going backwards, either from forest to, let's say, peaches or strawberries or something like that, you're going to need that income history of a few years. So it really depends which way you're headed. Now, the income, enrolling agricultural land in a conservation program that includes annual payments can still qualify that program. So you don't, in those instances, you're not in actual production, but because you're in a conservation program, you can qualify. But to the extent that those programs end, that qualification can end unless you have that income history across the farm that can justify it. So very good question. And there are details. Colby talked about the present use valuation guide, and he said page 78 has those references. In each example in that guide, they go through the back and forth from cropland to forestry, and they get specific, and that becomes a training manual for the county clerks who run that program. But thanks for that question.
Okay, here's a question from Kyle Ship. Does hunting or shooting on the property affect the forestry designation? And then can you also build, have buildings like equipment sheds be built on the forest land?
So the first answer is forestry or hunting are compatible, given local land use restrictions and zoning and the like. But that's not a problem. The building of equipment sheds may never be spotted by the county assessors. So in that case, they would be acceptable, but to the extent that they become visible from an aerial photograph or have a substantial value to them, they may be picked up as an improvement or an out structure. So for instance, if you put a shed in your backyard, the county usually can find it from an aerial photograph and you'll be assessed the $1,000 or whatever its value is. That would be the same case for forest land.
So, and it's always, if somebody's thinking about building a shed, for example, Mark, to store some farm equipment or something like that, probably best for them to check with their county tax office to see how it might impact their present use value program?
Or not, depending on where their building envelope is. For instance, if you have rural property and your house is assigned to it, or the house is on the same property, the county has probably already etched an acre around that house and excluded it from present use treatment. So if your building envelope is where your shed is going to be, it would not likely impact your tax on the forestry land at all.
But if you're outside that envelope, it's probably
that would
best
be
to check.
a good call to check.
Yeah. Okay. Next question is from Felton Wooten. He was wondering, they have a stream that runs through their timberland. Can someone speak more on the stream crossing plan?
I'm glad to. Colby, I'll let you take a first shot.
Yeah, you know, you can work with your local, you can work with local soil and water office, or also work with the Forest Service, or your forester to, you know, develop a plan on a stream crossing. Soil and water offices probably have the most expertise, usually when it comes to engineering those type of crossings, and in a lot of cases, NRCS and soil and water may have some cost share money available to help you with a specific type of stream crossing, whether it's temporary, you know, for a harvest, or a permanent stream crossing. They could help with the design, and in some cases help with making sure that you've got, you know, the right type of culvert sizing, and also help with cost share on that.
And I would just follow up that the State Forest Service has water quality foresters and other trained individuals that can help with a stream crossing. They also have a bridge mat loan program where if you're only need to get across a creek for limited time, like a harvest and the like, they do have a loaner program to use temporary bridge mats. They're steel decks, if you will, that are placed across the stream. Equipment can run across it, and then when you're through, they're taken out on the way out. So that's an option, but they also have software and the staff that can help you design one of those.
Okay, next question is from the chat window, and it's from Lloyd Singleton, wondering, does New Hanover County participate in the Voluntary Ag District Program?
Yeah, I just looked at the map, and New Hanover County does not have, they are not in the Voluntary Ag District Program, but you know, it might be they definitely, Mark and I are both on the state VAD work group, and they definitely would like to have all counties participating in the program. So Lloyd, it may be a good time to you know, have the discussion with the commissioners, maybe see what the possibility of getting the program started. And there's definitely folks with DeWitt Hardy with Department of Agriculture, who oversees the VAD program, would certainly be willing to help, and any of us on that state work group would be glad to help assist you with that.
Okay, the next question comes in from George. He's wondering, does Hoke County, North Carolina, well, it's also is one of only a few counties in North Carolina that is not designated as a voluntary ag district, and is wondering why.
So I'll let Kobe take the first shot at it, and then I'll finish up. Get him out of trouble if he needs it.
Yeah, I think Hoke County has been working on that for a while, and I'm not sure what the latest status is, but I think they're working on it. But there's some issues that they have to work out from a I guess either a political standpoint or a standpoint from the commissioners. But they are working on it. So if you want to chime in, Mark.
So Hoke County and some of the other counties may view the program as an obstacle to future development, and that may be a holdup. Sometimes it can be a philosophy of the local county commissioners, or if it's not a priority. A few of the eastern counties that we see not in the voluntary ag program are holding out that any lands are available for development, and so they don't want necessarily restrict their folks from having that opportunity. But it's variable. A lot of it is political. In the western part of the state where federal ownership is strong, it may be a tax-based issue. But each county is unique, and they have their reasons or their history, or opposition to them may be too strong for other groups to overcome.
Okay. So several people have mentioned about sharing the slides for today's presentation. Those slides are available on the forestry portal where you had logged on to today's session. So and I have already shared that out through all participants in the chat window. You'll see that link there. At this time, it looks like we've gotten through all of the questions. Let me just make sure we're not missing anybody. Nope, it does not look like we are. Are there any more questions that folks might have? This would be the time to share those. So yes, this webinar is being recorded, and it will be available on demand within a couple days at the same link as today's webinar. So you'll be able to, by getting back to today's webinar through the link you got by email, you should be able to view this webinar on demand here in a couple days. All right, let me just again thank our presenters today, Dr. Megalos and Mr. Colby Lambert, for taking the time out to share their experiences and knowledge related to today's topic. Thank you both, gentlemen. It was truly a great webinar. And with that, folks, thank you all, and we are done. Have a good day.
Appreciate it. Travel safe.
Yep. Thank you all.